Hello, I'm Amanda Moore. I'm the Director of the Clearinghouse Community. Welcome to the Advocacy Exchange for December 2017. The Advocacy Exchange is our monthly conversation with advocates advancing change. Both the Clearinghouse Community and the Advocacy Exchange are brought to you by the Sargent Shriver National Center on Poverty Law, a national leader in advancing justice and opportunity. The self-styled Federal Access Group. Some version of this group has been writing an annual recap of the previous Supreme Court term since 1993. They've been our Advocacy Exchange guests for the past couple of Decembers, and I'm happy to welcome them back again this year. Them in turn, and I'll start with Mona. Mona Tawatao is a senior litigator at the Western Center on Law and Poverty, which is a member of the Legal Impact Work. Mona is also a faculty member and an advisory board member of the Shriver Center's Racial Justice Training Institute. She joins us today from Sacramento, California. Also joining us from Sacramento is Gary Smith. Gary's the Executive Director of Legal Services of Northern California. Good morning to you, Gary.
Good morning.
And last but not least, we have Jane Perkins. Jane is the Legal Director at the National Health Law Program, and she joins us today from Carborough, North Carolina. Welcome, Jane.
Hi, everybody.
Supreme Court Recap is our latest Clearinghouse article. It's called Access Decisions in the 2016-17 Term, a mostly subdued U.S. Supreme Court in a year of political upheaval. At the address on my screen, it's the Clearinghouse Community, povertylaw.org/clearinghouse. And we're going to talk about the cases that they discuss in that article. But first, I want to let you know how you can be part of this conversation. We would love to hear from you. Most of you are watching this through YouTube Live, and if you're on a desktop or a laptop, you'll notice on the right side of your screen, there's a live chat box. Do that, you can submit your questions or observations. If you want to go ahead and give it a try, feel free. You can just send us your name and where you're watching. If live chat is not your jam, that's okay. You can use old-fashioned email. My email address is on the screen, and I'll be watching that for your questions or comments. My email address is Amanda Moore, M-O-O-R-E, no relation to Roy, at povertylaw.org. So let us hear from you, please. Registered for today's webcast. We'll get an email in the next couple of days. There you'll find a link to watch a recording of today's program, as well as a link to my guest's article and a link to register for next month's Advocacy Exchange. So be sure to keep your eye on your inbox for that. I see someone has said hello to us. Hi, Robbie. Robbie in Nebraska is watching. Thanks for tuning in and saying hello. Jane, Mona, and Gary, we would be remiss if we didn't begin today by noting the absence of your longtime co-author, Gil DeFord, who was formerly with the Center for Medicare Advocacy. So I'm wondering if any of you have heard from Gil lately, if he's out there living his best life. Gary, have you heard from him?
Gil, I have heard from him periodically. He has retired. He lives in the Boston area. He is enjoying his retirement. Gil, for those of you who don't know him, Gil was one of the most accomplished and prolific federal litigators in the legal services and public interest law community for decades and decades. And not only did he achieve tremendous benefits for low income and other disadvantaged folks through his work, but he worked in two support centers for many decades, the Center for Medicare Advocacy and also the Senior Citizens Law Center, now Justice and Aging. And in those capacities, not only did he do tremendous work, but he collaborated with attorneys across the country, younger attorneys like me in the 1980s and 90s, and we grew to appreciate and love our relationship with Gil. So he's doing well, and we miss him very much, and particularly his incredible sense of humor as we go about every year this article.
Well, thank you, Gary. Yes, we do miss Gil. That's a very nice tribute to him, though. Thank you. So I was thinking back to last year when we were together, and at that time, we were all preoccupied with what was going to happen to the Supreme Court with the soon-to-be Trump administration. We now know that we have a new Supreme Court Justice, Neil Gorsuch. Mona, what has this meant for the court?
Well, Justice Gorsuch didn't actually join the court until April of 2016. Most of the term, it was an 8-justice court. And in anticipation of being a justice down, what court observers say is that the court did not take the usual number of blockbuster kind of very divisive cases so as to avoid 4-4 decisions and which would have the effect of maintaining the lower court decision being appealed. So there were a lot of unanimous decisions or close to unanimous decisions, hence the word subdued in our title. Gorsuch did join in April of 2016, and he has shown himself, according to an article that Erwin Chemerinsky wrote for the ABA Journal in August, to be a very, 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 underline very, conservative justice right out the gate. He has voted 100% of the time with Justice Thomas on cases like the Plavin v. Smith case, which was in Arkansas, involved an Arkansas rule or policy that prevented same-sex couples from registering their names on birth certificates. The Supreme Court, in light of the right to marry, the Obergefell case from the 2015 term, in a per curiam decision said, this is an easy case. Of course, the same-sex couple should have that right to list their names. And Gorsuch was a dissenter in that. He wrote the dissent in what should have been an easy case. Same with the travel ban case, the Muslim ban 2.0 case, in which he was a dissenter when the court upheld. The court granted the stay of the U.S. government to partial stay of the Ninth Circuit and Fourth Circuit injunctions of the 2.0 travel ban, Muslim ban, but he dissented from the court's compromise, which was to say people from affected countries could, if they had a bona fide contact or had a relationship with an entity or person in the U.S., that they could, they would be exempted. But nevertheless, he and Alito and Thomas dissented and said, no, the Muslim ban should go into effect in its entirety. So he's shown himself to be extremely conservative, and that is the big news. But going back to those decisions, I mean, there's many cases about federal access that we are going to talk about today.
Yes, so let's get to those. We have a couple people who've said hello. Dorinda in Minnesota, and Greg, who says he is from the heart of Cajun country in Louisiana. So Dorinda and Greg, thanks for saying hello and tuning in today. Gary, I want to start with you. A lot of the cases that you all talk about in the article focus on statutory construction that are of interest to people in the poverty law field: the Federal Housing Act, the Fair Debt Collection Practices Act, the Individuals with Disabilities Education Act. Let's start with the FHA, the Fair Housing Act case, which was Bank of America versus City of Miami. Gary, can you tell us about that one and what the court said?
That was a case in which the City of Miami sued a couple of banks that had been already found liable in other contexts of racially discriminatory lending practices and predatory lending practices. And those practices, the city said, because they had disproportionate negative impact in minority neighborhoods, they impaired the city's municipal interest and effort in assuring racial integration in the city neighborhoods. And then the city claimed damages under the Fair Housing Act because of diminished property values and the increased greater municipal services cost attendant to some of the blight that occurred allegedly because of these practices. So, I mean, for those of us who have been concerned about the movement of the court in recent years, decades actually, towards restricting federal access and restricting the vindication of federal rights and remedies, this might have been a surprising result because the Supreme Court ruled that the city did qualify as a, quote, aggrieved person which had standing under the Fair Housing Act to raise these claims, which were subject to liability under the Fair Housing Act, and it was a 5-3 decision. Gorsuch was not yet on the court. This is one of those cases where if this court were writing on a clean slate under this statute, it would be surprising if they allowed standing to a municipality. But fortunately, for purposes of this decision, there was long-standing precedent under FEHA going back to the 70s where municipalities the Supreme Court had construed the Fair Housing Act to permit these kinds of claims. And so the case went forward. The court remanded the case to the Court of Appeals to look at sort of what the proximate cause relationship was. But the main question was whether this was a claim that could be asserted by a municipality under the statute was answered affirmatively.
The court also addressed intervention last term. The case was Town of Chester versus LaRoe Estates. Jane, can you tell us what we need to know about this case and intervention under the Federal Rules of Civil Procedure?
Sure. I think intervention isn't something that comes up a lot for us, but it does come up occasionally and is a good route to use if you don't need or want to amend your complaint. So Federal Rule of Civil Procedure 24A is the part of the intervention rule that concerns intervention of right. This case involved a land developer that sued the town of Chester, claiming that government red tape was delaying his ability to develop the land. LaRue Estates wanted in on this case because they said they had a contract with the developer to purchase parcels and to sell those and in the subdivision once the development was approved. The district court said to LaRue Estates, you can't come in because your interest is only an equitable one and we don't find that you have Article 3 standing. The Second Circuit Court of Appeals reversed, saying you don't need to have Article 3 standing to intervene as of right under Rule 24A. There was a split among the circuits created. The Supreme Court took the case and easily reversed. Justice Alito wrote the decision saying that standing is not dispensed in gross and that each intervener seeking compensatory damages or seeking to be compensated in the case has to establish Article 3 standing if they're seeking compensatory relief that differs in any way from the relief being sought by a party. Article 3 standing being a concrete injury that is fairly traceable to the conduct of the defendant and that is likely to be redressed by a favorable decision from the court. The court couldn't tell exactly what the differences, if any, were between the damages that LaRue Estates and the developer were seeking. So it remanded the case to the court for a determination of that. But the bottom line is that for intervention of right under Rule 24A, be careful and make sure that your interveners meet Article 3 standards.
Thank you, Jane. The Clearinghouse article that you can find here, povertylaw.org/clearinghouse, it begins with the case of Bristol Myers Squibb versus Superior Court of California. So this was a personal jurisdiction case about non-residents of a state. Mona, can you tell us why this case is significant, please?
Sure. This was a just to put it into context, it was a mass products liability class action that was filed in California state court by both California residents and non-residents. And they alleged that the drug Plavix, which is supposed to prevent blood clots, damaged their health. And Bristol Myers, the manufacturer of the drug, moved to quash the service of summons on the basis of lack of specific jurisdiction or personal jurisdiction. I think the real value of this case is the primer, if you will, that Justice Alito provides on that very exciting topic of personal jurisdiction. Another one of those near unanimous decisions, it's 8-1. And what he talks about is the Fourth Amendment limits on a state's exercise of personal jurisdiction, and the protection of defendants from the state's coercive power. So he explains in the opinion that there are two types of personal jurisdiction. There's general jurisdiction and specific jurisdiction. So the general jurisdiction is the kind of jurisdiction a state can exercise, say, where Bristol Myers is located, where it's headquartered. So if it's the state that the defendant can say is the home state or where it's headquartered, and then there is general jurisdiction. So that's not really what this case is about. The second type, specific jurisdiction, it requires an affiliation between the forum state and the underlying controversy, principally an activity or occurrence that takes place in the forum state and is therefore subject to the state's regulation. So that's what this case was about. But I think that primer, distinguishing the two, is important. What happened in that case was it went up to the California Supreme Court. And of course, Bristol Myers isn't headquartered here in California, so they said that that's not an issue. But the California Supreme Court actually split on the issue of specific jurisdiction. It applied a sliding scale approach that says that the more wide-ranging the defendant's contacts are in California, the less direct connection between the activities in the forum state and the plaintiff's claims are required. So therefore, this California Supreme Court majority decided because enough of the California residents and non-residents had similar claims, the fact that Bristol Myers conducted a lot of research in California, even though it had nothing to do with the drug Plavix, created sufficient contacts or activities such that there was specific jurisdiction. The Supreme Court, again, 8-1, said emphatically no, that the primary concern in determining whether there is specific jurisdiction is the question of, is there a burden on the defendant? And what Justice Alito meant by that was not just practical and logistical concerns like distance or inconvenience, but, quote, the more abstract matter of submitting to the coercive power of a state that may have a legitimate interest in the claims at question. So it's really, he's saying, a principle of fundamental unfairness. The Supreme Court majority said sliding scale approach is not the way to go, because noting that the non-residents in this case didn't have any prescriptions in California, didn't buy it here, ingest it here, not injured in California. So, I'm not sure, the facts of this case are probably not very typical of facts that we would be dealing with in our work. However, I think that primer and kind of describing what you need to establish specific personal jurisdiction is what's really helpful.
Thank you, Mona. I want to remind our viewers that we would love to hear from you. If you have questions about cases that came up in the last term, please let us know. You can live chat through YouTube Live, or you can email me at Amanda Moore, MOORE, @povertylaw.org. Let's turn now back to statutory construction. The court had, I think, maybe a couple of cases on the Individuals with Disabilities Education Act. Gary, what can you tell us about one of those cases, which was the Andrew F. versus Douglas County School District case?
Well, that case, I think, is a very significant case for anyone in the public interest community that advocates for children with disabilities in schools. In in 1979, I think it was, the Supreme Court decided its landmark decision in Board of Education versus Rowley, interpreting the Individuals with Disabilities in Education Act, and they ruled that Rowley ruled that the IDEA established a substantive right to a free, appropriate public education for children with disabilities. But in Rowley, the court declined to sort of describe what that standard might be in terms of its substantive content. So for decades, the lower courts have tried to figure out what the content of a free, appropriate public education means in the context of children with disabilities. And the court in this case, 10th Circuit, like most of the courts, had pretty much settled on a standard that said, well, if a child with disabilities is making some amount of minimal progress under the plan that the school is required to set up, that was probably all that Rowley required in terms of its substantive standard. In this case, somewhat surprisingly for some of us, the Supreme Court unanimously, in an opinion by the Chief Justice, said that no, that standard is not sufficient. A sort of a standard of minimal progress does not satisfy the IDEA as it was interpreted by Rowley. So Justice, and he sort of went back and forth, well, what should that standard be if it's not kind of a minimal progress in terms of your educational performance? And he came up with this definition. A student offered an educational program providing merely more than de minimis progress from year to year cannot be said to have been offered an education at all. So he rejects this minimal standard that many federal courts had thrown up their hands and said, well, that's probably all we can do. And so the court says in Andrew F., for children with disabilities receiving instruction that aims so low, it would be tantamount to sitting idly, awaiting the time when they were old enough to drop out. So that's pretty strong language about what the standard is not. And then he said that the IDEA demands an educational program reasonably calculated to enable a child to make progress appropriate in light of the child's circumstances. I'm not sure what that means, but at least it is an effort to provide some amount of substantive benefit under the IDEA, more than what the courts have been doing in past decades. So the lower courts will now struggle to try and figure out what this new standard is. But it's certainly a positive development for the disability rights community advocates.
So I know that several of our viewers are restricted because of funding from bringing class actions, but are. So I want to turn to one of the cases from last term about class actions and class certification in particular. That was Microsoft v. Baker. Jane, can you tell us what the court said there?
Sure, and I guess just to make it relevant to LSC programs that can't do class actions, I guess the takeaway would be, don't come up with a legal theory that a court is going to describe 8 times as a tactic, because that's a pretty good indication that you're going to lose the case. Microsoft Corporation versus Baker is a case that involves some gamers. They brought a suit against Baker as a gamer, and he brought a suit against Microsoft saying that the Xbox was scratching his discs. And he and a number of other gamers filed a class action case to get relief for that injury. The district court denied class, finding that there could be any number of reasons for a scratched disc. So at that point, the gamers turned to the Federal Rule of Civil Procedure 23F, and that's the part of the class action rule that allows the a plaintiff or a person who loses on class to make an interlocutory appeal to the Court of Appeals, and the Court of Appeals in its discretion can decide whether or not to allow that appeal. The Ninth Circuit refused and said, we're not going to take this appeal. at that point, they were the gamers did have a bit of a issue because there's a bunch of people with one or two scratched discs all around the country. So they could have pursued those individual cases, which would be kind of a difficult thing to do in terms of resources, or they could try to find a way to continue with their class action. And that's the avenue that they chose. And what they did was to take a voluntary dismissal with prejudice. And then at that point, they argued that under 28 U.S.C. section 1291, which is the rule of finality, which allows you to appeal a final decision, they appealed to the Ninth Circuit, arguing that the class action denial by the district court was an abuse of the district court's discretion. I think somewhat surprisingly, the Ninth Circuit took the case, heard it, and concluded that the district court had abused its discretion in denying class certification. The Supreme Court took the case, and I think this is a great law school question, whether courts of appeals have jurisdiction under Section 1291 to review an order denying class certification after the named plaintiffs voluntarily dismiss their case with prejudice. You know, also noting that you reference to tactic repeatedly, the way the court framed the question, I think also gives a little tip-off as to the way they're going to go. And they said, no, you can't do that. And their reasoning was very practical. They gave a number of reasons, but among them, it invites piecemeal litigation, it protracts litigation, it puts the control over the class decision solely in the hands of the plaintiff, when the defendant might have something to say and some concern about class as well. And then I think the one that was most powerful to the court is that the court said that it upset Rule 23F's careful calibration of finality and interlocutory appeal by vesting within the courts of appeals the sole discretion as to whether or not to allow an interlocutory appeal of a class action denial. So don't use tactics.
Good lesson from that one. So we're nearing the end of our time. There are a couple more cases I would like to ask, but I'll have to encourage you to make these quick takeaways if you could. Mona, so I'm always filled with dread when I hear that the Supreme Court has taken a case on arbitration. It sounds like my dread was well-founded last term with the case of Kindred Nursing Centers versus Clark. Can you tell us just briefly what happened with that case?
Yes, and you and we all should be filled with dread. I mean, I think the main takeaways are that this is a Justice Kagan decision, 7-1. The court is united on the preeminence of the Federal Arbitration Act. I think it's bad news for states that try to enact, have to be careful and almost impossibly clever if as a state you're going to enact laws that protect consumers on arbitration agreements. This was a Kentucky case, and the main takeaway from this case is whether it is an explicit type of policy that singles out arbitration agreements for challenge, or implicit, or the impact, I should say, of the state's policy it violates the Federal Arbitration Act. It doesn't matter, and that if there's any sort of limit on an arbitration act on arbitration, it can't be unique to arbitration agreements. It has to be the same kind of challenges you would bring to any other sort of agreement. If it uniquely singles out arbitration agreements, then you're in trouble under the Federal Arbitration Act, and the court is very solid on that, unfortunately. So that's the takeaway.
Got it. Thank you, Mona. Gary, I'm going to get you back on here. Oh, there we go. Nope. I thought I had you unmuted, and now you're muted again. But I'll go ahead and ask you what I wanted to ask you. So again, quickly, we're nearing the end of our time, but there was... Oh, I think we were going at cross purposes. Sorry about that. So for the consumer lawyers out there, one more statutory construction case we wanted to highlight. A couple of cases also about the Fair Debt Collection Practices Act. One of those, Henson v. Santander Consumer USA. Can you give us the quick and lowdown on that one?
This was one of Gorsuch's first opinions, so they gave him an easy one in terms of statutory construction, and all of his colleagues joined in it. And for those of you who do this kind of work, the Fair Debt Collection Practices Act was enacted in 1977, and it was designed to get at abuses by debt collectors, and it defined debt collectors as third-party entities that basically were hired or contracted with creditors to collect a debt on behalf of the creditor of another, as the statute says. So in this case, there was allegedly abusive debt collection practices by an entity that had purchased the debt, it had bought up the debt from a creditor, from a finance company, and was collecting the debt, but it owned the debt. So it wasn't collecting it on behalf of a creditor, it was collecting basically on behalf of itself. That there is a gap in the statute, because that practice of buying up debt and then going after the debtor really wasn't part of the industry in 1977. But the language was clear enough that Gorsuch and his colleagues all said, well, the statute says what it says. It says collect on behalf of another. If you're concerned about this problem of entities buying up debt and then collecting it for themselves, you have to go back to Congress and get them to amend the statute.
Thank you. Really quickly, just to end, Mona, we're already in the middle of the now 2017 term. What are some cases that we need to look out for this term? What are the cases that we might be talking about at this time next year?
Well, of course, there are the two blockbuster cases, the Gill v. Whitford case, which is the case that will decide the test for partisan gerrymandering, so it has huge implications. And then there's the Masterpiece Cake Shop case, another blockbuster case on Colorado's public accommodations law that has huge implications for the LGBTQ civil rights community as well as civil rights in general. So there's two blockbuster cases. On the access side, it's back to the Federal Arbitration Act. There are a trio of cases heard early, the first day of argument, and those cases pit the FAA against the National Labor Relations Act, which says that employees have the right to engage in concerted activities for mutual aid and protection, like joining together in a class arbitration. And unfortunately, so the question is, can employers impose limits on that? And unfortunately, to court observers who observe the argument, it's not looking good for employees and consumer rights. Again, the preeminence of the FAA to the detriment of consumers. Really quickly, I think on the court composition, though I'm loath and our post happiness about the outcome in Alabama to bring this up, but we just have to hope that Justice Ginsburg keeps up her rigorous workout regimen that 30-year-olds apparently can't do. Take heart in the fact that Justice Breyer is only 78, and that Justice Kennedy has not said he's retiring. At least he's being coy about it, because the new justices on Trump's list of 5 that he added to his current list of 20 are doozies, and I think I'll leave it at that.
15 or 20 years ago, it would have been remarkable to have people in our community rooting for Justice Kennedy to stay on the court.
Yeah.
Yep.
Yes, things change. Well, I want to thank the 3 of you for being here today, and thanks to everyone else for tuning in. I'll remind you, we, of course, couldn't get to all of the cases today that are in the article, so be sure to check out Mona, Jane, and Gary's article. It's called Access Decisions in the 2016-2017 Term, a mostly subdued U.S. Supreme Court in a Year of Political Upheaval. You can find that at povertylaw.org/clearinghouse. If you liked the content for today, please join our mailing list so you'll be notified of future articles and advocacy exchanges. That's at connect.povertylaw.org/clearinghouse. You can also subscribe to the Advocacy Exchange podcast. You can find that at Apple Podcasts or wherever you get your podcasts. I also want to invite you to join us for next month's Advocacy Exchange. We'll have a very special guest. It's Peter Edelman. He's the esteemed Georgetown law professor. He's also the author of this new book, The Criminalization of Poverty in America. I'll also be joined by John Bowman. He's the president of the Shriver Center, and he's writing a review of this book. We will talk about the book. We'll talk about the advocates highlighted in the book who are working to end the criminalization of poverty. Should be a really interesting conversation. Friday, January 26th, same time as today, 1 o'clock Eastern, 10 o'clock Pacific. We hope that you'll join us then. Be on the lookout for that email coming to you that will have the registration link in it. Until then, happy holidays, everybody, and remember that you're not alone out there. Thank you.
Bye, everybody.
Thank you. Bye.